In a stunning move early this morning, the Supreme Court issued an emergency ruling at 6:23 a.m. that effectively dismantles every firearm permit requirement across the United States. Advocates for gun control immediately decried the decision as a catastrophic blow to public safety, while gun rights supporters hailed it as a restoration of constitutional liberties. In one sweeping ruling, the court struck down concealed carry permits, purchase permits, and ownership licenses, any bureaucratic permission previously required in all 50 states. Those who have waited months for carry licenses or been denied firearm purchases now face a radically different legal landscape. This historic emergency ruling, issued on April 28, 2026, in the case of National Association for Gun Rights versus United States, declared all permit systems unconstitutional. The court held that requiring government approval before exercising Second Amendment rights constitutes a prior restraint, directly conflicting with the historical framework established in Bruin. Immediately, any permission slips previously demanded by state or federal authorities are invalid. The court's reasoning is clear. The Second Amendment protects an individual right that exists independently of government sanction. Authorities may still perform instant background checks to ensure prohibited persons do not access firearms, but they cannot mandate permits, licenses, or approval processes that delay or block lawful ownership. Every state and federal requirement that functions as a bureaucratic barrier is now unconstitutional. Permit systems removed instantly include concealed carry permits in all states, handgun purchase permits such as Illinois FOID cards, New Jersey purchase permissions, Massachusetts FID licenses, New York pistol licenses, waiting periods exceeding background check processing, mandatory training as a permit prerequisite, and all associated fees. Legal requirements that remain intact include background checks, prohibitions for felons and domestic abusers, age restrictions, 18 for rifles and 21 for handguns, and federal firearm license obligations for dealers. The line drawn is between verification of eligibility, which remains legal, and permission, which is now forbidden. The impact varies across states. In places with extensive layered permit systems, the change is revolutionary. Massachusetts, New York, New Jersey, California, Hawaii, Illinois, Connecticut, Maryland, Delaware, and Rhode Island all saw multiple permit systems struck down, instantly enabling citizens to purchase and carry firearms with only a background check. For example, Massachusetts FID cards and LTC licenses are eliminated, allowing immediate acquisition and carry. New York's pistol and carry permits are invalid, while Illinois FOID cards and purchase permits are no longer required. New Jersey residents lose handgun purchase and carry permit obligations. In California, waiting periods beyond standard background checks are now unconstitutional. States with moderate restrictions, such as Michigan, North Carolina, Washington, Oregon, Colorado, and Minnesota, experienced fewer invalidations, mostly affecting purchase permits or shall issue carry laws that previously imposed bureaucratic delays. Meanwhile, 25 states that already practice constitutional carry remain fully compliant and safeguarded against future permit attempts. This ruling fundamentally reshapes the exercise of Second Amendment rights, removing the need to request permission before legally obtaining or carrying firearms, while maintaining essential safety checks against prohibited individuals. It marks a dramatic departure from decades of layered regulatory systems, reinforcing the principle that constitutional rights cannot be contingent on government approval. Always double-check current statutes and seek legal guidance for specific circumstances. What was forbidden yesterday can now be exercised freely. Gun rights have expanded dramatically for millions of Americans. Firearms can now be purchased without any permits. You can enter a gun store, complete a background check, and leave with your firearm in hand. Weeks-long waits for purchase permits, void cards, or handgun licenses are no longer necessary. Instant eligibility verification is sufficient. Concealed carry is now legal nationwide without obtaining permits. You may carry handguns discreetly in public without licenses, though states can still restrict carry in sensitive areas such as schools and courthouses. Ownership of handguns no longer requires licensing. Residents of Massachusetts no longer need FID cards to legally possess firearms. In New York, pistol licenses are obsolete, and firearms may be owned like any other private property. Mandatory training requirements linked to permits can no longer be enforced. While training remains valuable, the government cannot make it a prerequisite for exercising constitutional rights. Waiting periods have been eliminated. Once a background check clears, typically in minutes, you can immediately take possession. 10-day delays in California and arbitrary bureaucratic holdups are now invalid. States are reacting differently. Immediate compliance has been declared by Texas, Florida, Arizona, and other constitutional carry jurisdictions, as these regions never required permits. Some states, including California, New York, and New Jersey, are reviewing the ruling and are expected to issue guidance within 72 hours, signaling potential resistance or exploration of legal workarounds. Massachusetts' governor has pledged alternative public safety strategies. Illinois' Attorney General announced emergency legislation to replace permits with different restrictions. Hawaii's officials labeled the decision dangerous and promised new regulations. The implication is clear. Some states will comply promptly, while others may attempt to substitute permits with certificates, eligibility cards, or rebranded approval systems. Such measures will likely face immediate legal challenges and be struck down under this ruling. At the federal level, the ATF confirmed that NICS background checks continue unchanged. Since federal permits never existed, compliance is automatic. The Department of Justice declined to comment on potential state resistance. Gun control organizations are mobilizing coordinated responses with substantial funding. Every town has announced campaigns totaling $50 million for alternative safety measures, including mandatory insurance, ammunition limits, safe storage mandates with inspections, and expanded prohibited categories. Groups like G-Ford have released model legislation promoting firearm registration, arguing it is not permitting ammunition licensing, magazine restrictions, and strategies to challenge the ruling through new lawsuits, attempting to distinguish licensing from permitting and pushing federal registry legislation. These efforts are likely to fail. The Supreme Court's decision relies on constitutional text and the historical tradition outlined in Bruin. Registration systems function as permission schemes, and ammunition licenses constitute prior restraints. The same principles invalidate these approaches. For the next 30 days, a clear action plan is essential while states adjust. First, confirm that you're not prohibited from possessing firearms. Background check denials may result from felony convictions, domestic violence convictions, restraining orders, adjudicated drug addiction, or mental health adjudications. If prohibited, this ruling does not grant rights. Focus instead on restoration processes. If you are eligible, immediately exercise your rights. Visit gun stores, complete background checks, purchase firearms, and begin carrying concealed if desired, without the need for permits. Step 3 is to meticulously document every transaction and interaction to ensure legal compliance and protect your rights during this transitional period. Keep all receipts, background check confirmations, and timestamps from purchases. If any state tries to enforce permits despite this Supreme Court decision, these records will demonstrate compliance with the actual law. Sensitive location restrictions remain intact. While the ruling abolishes permits, it does not remove federal or state bans on carrying in restricted areas. Firearms are still prohibited in federal buildings, schools, and other designated sensitive sites, and states may continue enforcing such restrictions. Mandatory training is no longer a requirement for exercising Second Amendment rights, but acquiring professional instruction is strongly recommended. Competence and safety are critical, and voluntary training ensures you handle firearms responsibly. Supporting litigation is also crucial. Gun rights organizations invested millions to secure this ruling, and they will spend millions more defending it against state attempts to circumvent the decision. Contributing to groups like SAF, FPC, and GOA helps maintain the momentum of this victory. Looking ahead to November 2026, the composition of future Supreme Court appointments will depend on elections. Registering and voting is essential to protect these gains and prevent erosion of Second Amendment rights. This ruling is historically significant, representing the most substantial restoration of gun rights in American history. It builds upon key precedents. Heller in 2008 recognized an individual right to bear arms. McDonald in 2010 applied it to the states, and Bruin in 2022 established the historical tradition framework. The 2026 decision now invalidates all permission systems nationwide. The impact is staggering. 43 states had some form of permit requirement, all of which are now struck down. Over 180 million adults may now exercise Second Amendment rights without government authorization. More than 400 different permits, licenses, and approval requirements have been eliminated in a single ruling. States will attempt workarounds, but these will face legal challenges. Lower courts are required to follow Supreme Court precedent, and hundreds of lawsuits are expected to strike down any attempts to reimpose permission systems under new names. The final legal battles will likely extend to assault weapon bans, magazine capacity limits, and ammunition restrictions, which will be challenged as prior restraints. Registration schemes will also be targeted as impermissible permission systems. State resistance litigation is expected to continue through 2026 and 2027, with assault weapon ban cases potentially reaching the Supreme Court between 2027 and 2028. Full restoration of Second Amendment rights is projected by 2029. In practical terms, the Supreme Court issued an emergency decision at 6:23 a.m. on April 28, 2026, nullifying all firearm permit requirements nationwide. Concealed carry permits, purchase permits, and ownership licenses are unconstitutional. 43 states must eliminate their permit systems, freeing over 180 million adults to exercise gun rights without bureaucratic approval. The era of requesting government permission to own or carry firearms is over. Today, citizens can purchase firearms with only background checks, carry concealed without permits, and own handguns without licensing. Second Amendment rights are immediately actionable. Despite this ruling, some states are already planning workarounds. California, New York, Massachusetts, and Illinois are exploring alternatives such as registration systems, ammunition licensing, or insurance mandates. All such measures will be challenged using the legal framework established by this decision. Gun control groups are mobilizing campaigns exceeding $50 million for alternative restrictions, proposing federal legislation, and filing new lawsuits. They will not concede without effort. Your immediate action items remain critical. Exercise your rights now, document every transaction, pursue voluntary training, support litigation groups financially, and participate in elections to protect these achievements. This is a constitutional restoration of the Second Amendment as written. No prior restraints, no government permission, no infringement. The court affirmed the founders' intent. Eligibility may be verified, but rights cannot be withheld. The Supreme Court has freed 180 million Americans from permit systems, and defending this victory is now paramount.